Welcome to today's talk at the Faculty of Law at the University of Hong Kong. My name is Sida Liu. I'm a faculty member here in the law faculty. So it's my great pleasure today to welcome Professor Camden Hutchison from the University of British Columbia to join us giving this talk. And Professor Hutchison is the Associate Professor of Law at the Peter Allard School of Law at UBC, and he's also the Director of the Center for Business Law at UBC. And Camden is old friend of mine. We actually got to know each other more than 10 years ago at the University of Wisconsin-Madison because Camden, other than being an expert on corporate law, he's also a legal historian. He actually did a PhD in legal history, look at the history of corporate law in the US at the University of Wisconsin. And after he got his JD from Columbia Law School and practiced in corporate law firms for several years. Right, and so Camden will be our speaker today. So we're also very honored to have my colleague, Dr. Stephen Lowe, joining us. Dr. Lowe, of course, is one of our top experts in corporate law here on our faculty. So Stefan will be our commentator today. So the talk title of today is Reassessing the End of History, Directors' Duties and Shareholders' Rights in Comparative Context. So without further ado, I'll give the floor to Camden.
Well, thank you so much, and thank you everyone for coming out. So today I'm going to be talking about my recent article project, Reassessing the End of History, Directors' Duties and Shareholders' Rights in Comparative Context. This is an article project that I just recently finished, and I submitted for publication a couple of weeks ago. I've submitted it to law reviews in the US, and so for anyone who's not familiar with the way that legal academic publishing works in the United States, it's this absurd system where you submit to like 50 journals at once, and it's just a total free-for-all, and you have to like check your email every day to see if you've got an offer, and it's all very stressful. So I'm going through that now, and I have not yet received an offer, but knock on wood, hopefully I'll get some good news, and this will actually get published. But let me tell you about this article project. I'm going to start out by setting the theoretical stage to just make sure that everyone is backgrounded for the research I'm going to discuss today. So by way of background, corporate law scholars have advanced a number of different competing theories of corporate governance, and I've listed a few of the major theories on this slide. So the first is shareholder primacy. This is a theory which states that corporations are or should be governed in the interest of maximizing the financial return to shareholders. That's shareholder primacy. The second I have here is director primacy. Director primacy is similar to shareholder primacy in that it states that corporations should be managed to maximize the financial interest of shareholders. But rather than giving shareholders direct decision-making power under the director primacy model, power to govern the corporation is invested in an independent board of directors that is largely immune from direct shareholder interference, right? So that's sort of a slightly different model, most often associated with the work of Stephen Bainbridge in the US. The next one I have here is team production. This is most associated with the late Lynn Stout. The team production model posits that the board of directors serves as a mediating agent, which balances the interests of not only shareholders, but also a number of other corporate constituencies, including employees, customers, suppliers, potentially broader social interests. The next one I have here is enlightened managerialism. Again, this is another model that posits that the board of directors should govern the corporation not to maximize shareholders' financial return, but instead to maximize the social benefits that the corporation is providing. This is often described in terms of the ESG framework, so maximizing environmental, social, and governance interest. And then finally, the public control model is a model in which corporations are directly or indirectly controlled by the state, presumably for the social benefit. So these are kind of some different models of corporate governance, and a central debate in corporate law scholarship is between what I characterize as shareholder models on the one hand and stakeholder models on the other. So shareholder models of corporate governance posit that the purpose of the corporation is to maximize the financial return to shareholders, whereas stakeholder models of corporate governance posit that corporations should serve broader social or community interests. So on this slide here, I would say that the shareholder primacy and the director primacy models are both examples of shareholder-oriented corporate governance frameworks, whereas the team production, enlightened managerialism, and public control models are stakeholder frameworks. Okay, so that's kind of the background. My specific article project is actually a response to a well-known corporate law article in the US that was published in 2001. So about 25 years ago, Henry Hansman and Reiner Krochman of the Yale Law School and the Harvard Law School, respectively, published an article entitled "The End of History for Corporate Law." And this is a very kind of one of the more famous articles in the last 20 or 30 years of US corporate legal scholarship. And in this article, they argued that around the world, corporate law has converged on a model of shareholder primacy and minority shareholder protections. So they argued that around the world, corporate law is converging on a shareholder-focused model of corporate governance in which the financial interest of shareholders are given priority. Hansman and Krochman provide surprisingly little empirical evidence for their claim. So most of the direct evidence in their article is taken from US law, and they sort of assert that this is a broader global phenomenon without really providing a lot of evidence from countries other than the US. This article made, a big splash. It was quite provocative, and it provoked a lot of criticism. So there's probably a couple dozen of articles that have been written in response to Hansman and Krochman, essentially arguing that they're wrong, that corporate law around the world is not converging on a shareholder primacy model, and that corporate law in other non-US jurisdictions allows the board of directors or the board of supervisors to consider broader social or community interests. These critiques of Hansman and Krochman are also kind of surprisingly devoid of empirical evidence. Many of these I would describe as sort of exceptionary arguments. They'll sort of present a case study of a single country that doesn't align with Hansman and Krochman's argument as evidence that Hansman and Krochman are wrong. So for example, the people will be like, well, in Canada, the law is like this, therefore Hansman and Krochman is wrong. Or in Australia, the law is like this, therefore Hansman and Krochman are wrong. But it's hard to tell if these are really, meaningful critiques of Hansman and Krochman's core argument, or if they're just exceptions that prove the rule, right? So there's been a lot of debate on this subject, right, is kind of the point I'm trying to make, but relatively little evidence. So my paper attempts to fill this gap by comparing corporate legal provisions across 60 jurisdictions. So I did a fairly large-scale empirical examination of the written law in 60 different jurisdictions around the world in order to effectively test Hansman and Krochman's argument that corporate law is converging globally. So I have a database of 60 jurisdictions, and the countries in that database were selected for legal, geographic, and economic significance and diversity. And I would describe my data set of jurisdictions as basically I would describe it as a non-random but representative sample of countries, right? And so I tried to get a sort of balanced diversity of commercially significant jurisdictions, and I selected for diversity in terms of legal origin, by which I mean civil law versus common law, cultural and colonial patterns. So I tried to choose countries that, were former English colonies, former French colonies, in some cases, former Dutch and Portuguese colonies, geographic patterns. So I just, tried to pick countries from different parts of the world, both developed and developing economies. And then finally, there's diversity in political models. So I have countries that are liberal democracies on the one hand, and authoritarian regimes on the other, and everything in between. So like I said, it's sort of a non-random but hopefully representative sample of different jurisdictions. For each of these jurisdictions, I coded 15 binary variables, right, giving a total of 900 data points. And the variables that I used were selected in order to reflect shareholder empowerment, by which I mean the degree of power and involvement shareholders have in key corporate decisions. So in these variables, there's a focus on, for example, directors' duties, right? So the relevant question here is whether directors' fiduciary duties are owed exclusively to shareholders and to maximizing the financial interest of shareholders, or alternatively, whether directors are allowed to consider broader social or community interests. I looked at whether or not there is a requirement that there be some number of independent directors on the board of governance of the corporation. So by independent, I mean independent of the executive management of the corporation. I looked at the ability of shareholders to remove and replace directors on short notice. This turns out to be one of the most important variables. I looked at whether or not there are oppression remedies, and by oppression remedy, I basically just mean an equitable shareholder remedy that is similar to the English oppression remedy. Whether or not shareholders can bring derivative actions for breaches of the director's fiduciary duties, whether or not a supermajority of shareholders is required to approve fundamental changes, such as mergers and acquisitions, and then finally, whether there's statutory anti-takeover provisions that allow directors to block hostile takeovers, even in circumstances where a majority of shareholders want the takeover to occur. So this on the list here. I would say that these turn out to be the most important of the variables that I looked at. Okay, so when I entered this empirical study, what was my hypothesis? Well, my preliminary hypothesis was that Hansman and Krachman are mostly right. That was my best guess, that yeah, around the world, corporate law probably is basically converging on a shareholder primacy type model. That was my hypothesis. And the reason for that is I suspected that the diversity in directors' duties observed around the world, right? So, and when I say diversity in directors' duties, I mean that although many jurisdictions require that directors maximize shareholders' financial return, many jurisdictions also allow directors to consider non-shareholder or non-financial interests. I suspected that this apparent diversity in shareholders' duties was mitigated by strong shareholder rights to replace directors who are not doing what they want, right? That's kind of my hypothesis. So I'll come back to this at the end of the talk, and we can talk about whether or not my hypothesis was true. Okay, so now I'm going to go through, and this is like maybe slightly boring, but I'm just going to kind of go through my empirical results because I think they are important for my ultimate conclusion at the end. So in terms of the variable of fiduciary duties, right? So basically whether or not fiduciary duties are owed narrowly to the goal of maximizing shareholders' financial return, or whether they're owed broadly to community and social interest. I found that more than half of all jurisdictions, including Delaware, limit fiduciary duties exclusively to the corporation itself, and by basically I mean the profits of the corporation or shareholders. So in slightly more than half of all jurisdictions, there does appear to be a clear duty on the part of directors to maximize the profits of the corporation. And then in a little bit less than half, directors are explicitly empowered to consider other broader alternative interests. So pretty good diversity there. There is a sort of significant minority of what I term in the slide to be Germanic countries. Basically, I just mean countries in Central and Northern Europe that are influenced by the German civil law that have co-determination rights and thereby impose broader fiduciary duties. So by co-determination, what I mean by co-determination, in Germany and other countries that are influenced by the German civil law, there's a co-determination model in which the employees of the company have formal representation on the board of directors. This is like Germany is sort of the most well-known example of this, but there's actually a number of countries in Central and Northern Europe that feature this governance model. And in all of these jurisdictions, the board of directors is explicitly empowered to consider non-shareholder interest, which makes sense because they're, the board of directors is at least partly representing the employees. So of course they have to consider the employees' interest. They can't only consider shareholders' interest. But aside from this, sort of subpopulation of co-determination countries, there's really no pattern whatsoever in terms of what jurisdictions have narrow shareholder obligations and what jurisdictions have broader directors' duties to consider broader interests. In terms of shareholder meetings, I found that shareholders have the right to call special meetings and remove the board of directors in most jurisdictions. So Hong Kong is a good example of this. Under the Hong Kong Company Act, a small minority, so 5% of the shareholders can basically call an ad hoc shareholders meeting at any time, and then a majority of the shareholders can remove and replace the directors, right? And in Hong Kong, majority of the shareholders can actually remove and replace the directors through a written resolution. So you don't have to have a shareholder meeting at all. Now, the significance of this is it makes it very easy for a majority block of shareholders to replace directors who are not doing what they want, right? This places very significant constraints on the board of directors and the board of directors' independence from the shareholders. So that's the norm. That in most jurisdictions, it is very easy for shareholders to remove and replace directors, right? That's kind of the important point. Some notable exceptions include, interestingly, Delaware. Also, I have Germany and China here. So Delaware is a unique jurisdiction in many ways. That's one of the conclusions of my project, is that Delaware sort of stands on its own. It's really not like any other jurisdictions in a number of ways. Germany is a co-determination jurisdiction. So in almost all co-determination jurisdictions, you cannot remove directors before the expiration of their term, right? So if they're elected for a year, you can't remove them until after a year has passed. If they're elected for 3 years, you can't remove them until 3 years have passed. You cannot just, at a moment's notice, remove the directors. Also, China, interestingly, in China, there was quite recently a fairly broad co-determination provision was inserted into the Chinese corporate law. And so in my study, China is the only non-European country that has a co-determination system. And, concomitant with this, the shareholders do not have the power to remove the board of directors whenever they want. The board of directors are more insulated from shareholder interference, and they have more control over the corporation. So I argue in this paper that the ability to essentially remove directors on moment's notice or remove directors whenever the shareholders want, that this is a very, very important constraint on directors' independence, and it limits the practical ability of directors to do anything other than maximize the shareholders' interests, right? Because if they, they decide that the corporate purpose, even if they're empowered under their fiduciary duties to consider, the environment or to consider the employees, if they're considering those interests in a way that is not in alignment with the shareholders' goals, which is typically making as much money as possible, they will simply be removed, right? So this is an important constraint. In terms of supermajority voting, I found that fundamental changes, so amendments to the constitutional documents, mergers, amalgamations, that type of thing, generally require a supermajority shareholder vote in 48 countries, so a pretty sizable majority. Again, there's no clear pattern here. I would note that Delaware does not require supermajority voting. Getting ahead of a bit of myself, but one of my key conclusions in this paper is that, ironically, shareholders are relatively disempowered under Delaware law, which is probably not what a lot of people would expect. Shareholder majority voting requirements, I argue, their consequences are a bit ambiguous, but I essentially argue that they give shareholders power vis-a-vis the directors. So if there's a requirement to get a supermajority vote of shareholders to engage in any kind of fundamental corporate transaction. That's particularly empowering for controlling shareholders, because controlling shareholders with a sufficient shareholder block can simply prevent those transactions. In terms of anti-takeover statutes, those are relatively rare. Only 4 jurisdictions in the database, Belgium, France, Pakistan, and Delaware, have anti-takeover statutes. Anti-takeover statutes are very shareholder disempowering. They grant the directors a lot of power to do what the shareholders do not want them to do. So anti-takeover statutes are generally shareholder disempowering. Now, the reason that these jurisdictions, particularly Delaware, have anti-takeover statutes, the inference from this is not necessarily that all jurisdictions that don't have anti-takeover statutes have made some kind of conscious policy choice to empower shareholders. It may be simply that there are not a lot of hostile takeovers in those jurisdictions, and so the issue has never arose, right? So there was a period in the 1980s and 1990s where there was a lot of hostile takeovers under Delaware law, and corporate management in the United States essentially lobbied the Delaware state government to introduce this anti-takeover statute. So it's basically a kind of a reaction to hostile takeovers that occurred in the US. Same thing in France. There was attempted takeovers of a number of sort of politically important French companies, which resulted in the passage of an anti-takeover statute. But in a lot of countries around the world where financial markets are less liquid and a lot of companies are controlled by controlling shareholders, there just aren't a lot of hostile takeovers, right? It's very hard, if not impossible, to do a hostile takeover of a company that has a controlling shareholder, because if the controlling shareholder doesn't want to sell, they won't sell and there won't be a hostile takeover. So the reason that anti-takeover statutes are so rare may simply be because hostile takeovers are relatively rare in most jurisdictions. And then finally, or not finally, almost finally, in terms of the oppression remedy, 24 jurisdictions feature oppression remedies, mostly common law countries, which is not surprising. The oppression remedy comes originally from English law, and so most of the countries that have oppression remedies are common law jurisdictions. However, there are some civil law jurisdictions that have adopted equitable remedies that are similar to the oppression remedy. I would note that Delaware is the only common law jurisdiction in my database that does not have an oppression remedy. Oppression remedies are pro-shareholder. They are empowering of shareholders. So again, this is another example that Delaware, somewhat surprisingly, I would argue, ironically, is a relatively shareholder disempowering jurisdiction. So shareholders have relatively less power in Delaware. And then finally, in terms of derivative actions, they're quite common. So 52 out of 60 jurisdictions allow shareholders to bring derivative actions to sue for breaches of fiduciary duty. Public enforcement of directors' duties is relatively rare. So by public enforcement, basically what I mean by that is jurisdictions where the government can bring lawsuits against directors for violating their fiduciary duties rather than shareholders bringing private actions themselves. Australia is an example of a country where the government can and does bring lawsuits against directors for breaches of their fiduciary duties, but like the US, Canada, that doesn't happen. Okay, so what did I do with this data? I took my results and I created what I term in my article a shareholder empowerment index, which is what it sounds like. It's a measure of shareholder empowerment. I did this. I have 15 binary variables for each jurisdiction, and I coded the variables such that 1 is a pro-shareholder value and 0 is a null or anti-shareholder value, right? Such that you can simply add up the values of the binary variables and you get a score between 0 and 15, 0 being a perfectly anti-shareholder jurisdiction and 15 being a perfectly pro-shareholder jurisdiction. So it gives you this kind of rough metric of how pro-shareholder the laws are in a given jurisdiction. The results were interesting and surprising to me. So I'll give you a flavor for this. The highest scoring jurisdiction in the database was Kazakhstan with 14. The lowest was the Netherlands with 6. Delaware was quite low. It was tied for second lowest at 7, and just FYI, Hong Kong is about average at 10. 10 was the average, just about 10 was the average score, right? So you look at this and you're like, like, I don't know how many people were expecting that Kazakhstan would be the world leader in shareholder empowerment, but it's actually like kind of not a fluke. So it's like Kazakhstan is the number one. And then like also very high ranking countries include Nigeria, Philippines, right? So there is no correspondence whatsoever between this shareholder empowerment index and the wealth or the economic development of the countries, right? The Netherlands scores the lowest. Other very low scoring countries include Norway, Sweden, right? These are some of the richest countries in the world. So in no way does this index reflect wealth or economic development. And you might be thinking, why would it? Well, a lot of people have argued that there's actually a direct relationship between corporate law that's empowering of shareholders and economic development. So there's, quite a lot of scholars in the corporate law area have argued that, countries, like rich countries are rich because they have shareholder empowering corporate law, or poor countries or less rich countries are less rich because they have corporate law that's hostile to shareholders. I don't think that that's a very plausible argument, but a lot of people have made that argument. It's certainly not supported by the evidence that I have found. Now, these additive scores, I would say, provide only a rough estimate of shareholder empowerment, but they need to be used with caution. So probably the most important caution I would give to anyone reading my paper is that my paper measures only written law, right? It measures only nominal law. It does not reflect actual law, right? So kind of the law in the books versus law in action distinction from sociology of law is evident here. I'll just give one example. So Vietnam scores quite high. If you look at sort of nominal Vietnamese law, it seems quite pro-shareholder. But based on everything I've read about the actual corporate law situation in Vietnam, shareholders' rights are very rarely enforced for a number of reasons. The judicial system is not very effective. There's a lot of corruption. Courts are generally not receptive to shareholders' claims. So even though it seems on paper like a jurisdiction that would have strong shareholder rights, in reality, it doesn't. So my index does not capture that. It does not attempt to capture that, and that's certainly a weakness of my study. Another, not a weakness, but kind of a wrinkle is there's a distinction between shareholder empowerment and shareholder protection, which I basically elide. So a lot of past scholars who focus on shareholder empowerment, and Hansman and Krachman fall into this category. They focus on two things. They focus on the sort of general empowerment of shareholders in the abstract, and then they also focus on minority shareholder protections. But there's a sort of unacknowledged tension in focusing on these two things because shareholder empowerment is generally instantiated by the ability of a majority of shareholders to accomplish what they want, whereas minority shareholder protections are the opposite, right? Minority shareholder protections protect minority shareholders from the majority that's controlling the corporation, right? So this is, I would say this is sort of theoretically unresolved in a lot of the past scholarship. I just sort of elide this entirely by only focusing on shareholder empowerment. I don't really focus on minority protections. So to the extent that my index measures shareholder empowerment, it measures the empowerment of either a majority of shareholders or controlling shareholders. And that's actually part of my argument, kind of jumping ahead a little bit. But what I argue is that most jurisdictions around the world are very empowering of controlling shareholders specifically. And that's not a huge surprise because most jurisdictions around the world are characterized by many corporations that have controlling shareholders. Okay, so what are the conclusions from all this empirical research? Well, I think that my hypothesis going into this is basically correct. There does appear to be convergence in corporate law. So I think that Hansman and Krachman were basically right, that there is convergence in corporate law on a model of corporate governance that empowers shareholders and allows shareholders to get what they want. That is supported in my evidence. One surprising result, however, is that Delaware is a sort of unique outlier from this general shareholder primacy model. So it does seem like jurisdictions around the world are converging on a shareholder primacy model in which corporate governance is oriented towards maximizing the financial interest of shareholders. Delaware is an outlier from this model in that shareholders are relatively disempowered under Delaware law. Delaware is a good example of a director primacy jurisdiction. But ironically, like Delaware has this sort of weird combination of features that in Delaware, there is a very clear shareholder wealth maximization norm in the sense that under Delaware law, directors' fiduciary duties are owed exclusively to shareholders. That's very clear under Delaware law. So directors of corporations that are organized under Delaware law have a duty to govern the corporation in a way that maximizes the long-term financial interest of the corporation shareholders. However, the board of directors is very insulated from direct interference by the shareholders themselves. So it's a sort of indirect model of corporate governance where even though directors owe their duties to maximizing the financial return of the shareholders, they're actually not accountable to shareholders in the same way that they are in other jurisdictions. So this is sort of a kind of Delaware stands alone type argument. There's also no clear relationship between shareholder empowerment and economic development. And again, I mean, you might be like, duh, like why would there be? But a lot of ink has been spilled by people who argue that there's a direct link between shareholder empowerment on the one hand and actual economic outcomes on the other. So why is Delaware the way it is? Why is Delaware sort of unique among the world's jurisdictions? Well, I argue that Delaware law may be well suited to the American model of diffuse corporate ownership. So in the United States, and for those of you who don't know, Delaware is the jurisdiction under which most publicly traded corporations in the United States are organized. The United States has been characterized historically by very large corporations that are owned by very, very large numbers of diffuse anonymous shareholders, right? So they're very, very broadly owned such that no individual shareholders or group of shareholders has any effective control over the company. Well, I argue that the sort of director-oriented framework of Delaware law may be well suited to this type of ownership structure because when you have diffuse anonymous shareholders, they face very, very significant collective action problems in governing the corporation, right? They're unable to communicate with each other. They may have divergent interests. They're unable to coordinate their decision-making. And so it makes sense to take the power to govern the corporation away from the shareholders and to invest it instead in an independent centralized board of directors that manages the corporation on their behalf and is legally required to do so, right? That's kind of the Delaware model. This sort of historical reality of highly diffuse corporate ownership is not the standard around the world. It's characterized the United States historically, it's characterized the UK historically, but it doesn't really characterize most other countries in the world. So most corporations in most countries around the world have historically been dominated by controlling shareholders. And so in most jurisdictions around the world, you see corporate governance systems in which the shareholders themselves have much more power, which kind of makes sense if you have controlling shareholders who do not face the collective action problems that diffuse shareholders face, right? So controlling shareholders, they don't have divergent interests. They don't have problems communicating with each other. They don't, have coordination problems, right? If you think about like a stereotypical publicly traded company in Europe or in Latin America or in a lot of Asian countries, it's often dominated either by a family group or by a financial institution or by an entrepreneur potentially. And so it would make sense to give those controlling shareholders the ability to replace the board of directors with whoever they want because they don't face the same collective action problems that diffuse shareholders face in governance. So I argue that Delaware is unique because of the unique financial history of the United States, which is actually a lot different than corporate ownership patterns that you see in other countries. So one question is like sort of kind of a chicken or egg question, but like, one question might be, does Delaware invest power in the board of directors because of diffuse corporate ownership, or does diffuse corporate ownership exist in Delaware because power is centralized in the board of directors? I think it's much more likely that the law is reflective of the reality. I don't think that the financial reality is somehow an outcome of the law, right? So I think that sort of the financial reality in jurisdictions is the causal factor, right? And then the law reflects that, right? The law develops in a way that is responsive to the financial reality in different jurisdictions. Okay, so kind of just sort of a last point. So one of the things that I argue is that most of the jurisdictions that I look at feature either a strong shareholder wealth maximization norm in which directors are required to maximize the financial interests of shareholders, or they grant shareholders the power to remove and replace directors essentially whenever they want. Either of these two models seem unlikely to allow for meaningful deviation from shareholders' interests, right? So on the one hand, if directors are legally obligated to maximize shareholders' financial returns like they are in Delaware, then they will probably do that. But even in jurisdiction, like Canada, for example, so my home jurisdiction, or my adopted jurisdiction of Canada, under Canadian law, directors of corporations are explicitly empowered to consider non-shareholder interests, right? They're explicitly empowered to consider employees, to consider customers, to consider suppliers, to consider the environment, right? Which sounds nice until you realize that the shareholders have the ability to replace the directors whenever they want, which is a very significant constraint on the directors doing anything that is inconsistent with the shareholders' interest. And in my other prior research, not in this paper, but I've done empirical research on directors' decision-making in Canada, and what I found is that in publicly traded companies in Canada, despite what appear to be very broad fiduciary duties that allow directors to do, engage in all these kind of pro-social decisions, they basically never do. That directors in Canada always prioritize the financial interest of shareholders. That's very clear. So they don't act any differently from Delaware directors, right? So one of the arguments that I make in this paper, and it's kind of a running theme in a lot of my papers, is I don't think fiduciary duties matter very much. I think that directors' decision-making is determined much more by practical and economic constraints than it is by the nature of their fiduciary duties, right? So not only do directors who face the threat of being replaced by the shareholders, not only do they have a practical constraint to do what shareholders want, but often, and this might be as important, if not more important, often their compensation is tied to share value, right? So they're strongly economically incentivized to maximize the share value of the corporation rather than engage in other pro-social activities. One of the arguments that I make sort of in my conclusion is that nominal fiduciary duties, which are really, I think that this point kind of bears emphasis, because I would say like the last 20 years of corporate law scholarship, certainly in the United States, has kind of been preoccupied with fiduciary duties. And there's been a tremendous amount of debate over, both normative and positive, over what fiduciary duties are or what they should be. And I argue that probably doesn't matter that much. It's probably directors' practical and economic incentives that matter more in terms of shaping their actual decision-making. So anyways, that is my presentation, and I look forward to comments and questions. Thank you.
Thank you very much, Camden. And Stefan, our commentator.
Okay, so thank you, Professor Hutchinson, for your insightful talk. In these next few minutes, I would first of all like to offer some general comments on the topic and on Professor Hutchinson's presentation. I would then like to say a few things about the historical context of the shareholder primacy model of company law. Then finally, a few comments on the Hong Kong context and the previous debates in Hong Kong following UK debates on whether to move towards a stakeholder model of corporate governance. So firstly, some general comments. So the shareholder primacy versus the stakeholder approach in corporate governance has been an important one. So that debate has been an important one for a number of decades now, and continues to be important today. For a while now, and despite some recent pushback in some sectors, many large corporations around the world have moved towards adopting ideas of corporate social responsibility. So corporate social responsibility, CSR, do adopt ideas of a stakeholder model of corporate governance. And in more recent years, the phrase environmental social governance, ESG, has been used to denote commitments of corporations to act to protect interests of other stakeholders. So whether employees, customers, creditors, or the wider community, to promote sustainability more broadly. Many corporations have given some degree of focus on these ESG matters. But it is interesting to note that despite these developments, many corporate law regimes around the world are still pretty much based on a shareholder primacy model of corporate governance. The research discussed in Professor Hutchinson's presentation this evening provides clear data in showing this across both common law and civil law jurisdictions around the world. There are many insights provided by Professor Hutchinson's research. I highlight two. Firstly, the research is important in the comprehensiveness of the comparative analysis. So in looking at both common law and civil law jurisdictions in different places around the world, across Asia, the Middle East, and Africa, and not only limited to the usual European and American jurisdictions, which are typically studied in the Western legal literature. Secondly, a major focus of the existing academic literature on the shareholder primacy stakeholder model debate is on directors' fiduciary duties. The basic question there is whether directors should be under duties to act solely in the interests of the shareholders, or whether directors should be taking into account the interests of other stakeholders, which are not necessarily going to be subordinate to the interests of shareholders. So much of the literature focuses on that, but as we saw from Professor Hutchinson's presentation, it's also important to look more broadly at shareholders' rights and powers to see the extent to which the legal framework upholds shareholder primacy. And indeed, most company law regimes are still dominated by the concept of shareholder primacy, with significant shareholder powers being conferred in their control over the board. I want to put this in the historical context in the case of Anglo-based common law jurisdictions. In such jurisdictions, shareholder primacy originates in part from earlier views that directors are simply agents of the shareholders in running the corporation, and hence directors need to act solely in the interest of shareholders. Today, from the legal perspective in England and Hong Kong and similar jurisdictions, directors are no longer seen as agents of the shareholders as such. However, the earlier views on the primary position of shareholders has shaped much of company law from the 19th century to today. So we still see that shareholders have powers to appoint and remove directors. And also, while the directors fiduciary duties are to act in the interest of the company, the case law makes it clear that generally the interests of the company means the interests of the shareholders as a whole. So this is the Hong Kong position. Hong Kong law is still based on shareholder primacy, and this is provided for both through the nature of fiduciary duties of directors and also through the various rights and powers which shareholders have in company law. Although there has been much emphasis on corporate social responsibility and ESG in recent times, there have not been fundamental changes made to black letter company law to actually promote this. But law reform to move towards a stakeholder approach has been looked at in the UK and in Hong Kong to a certain extent. So in my final comments, I'll just say a few points about the reforms looked at. In the UK, before the enactment of their present Companies Act of 2006, there had been debate on whether to adopt a pluralist or a stakeholder approach in looking at the fiduciary duties of directors. So the focus in that debate was on the specific duty to act in the interests of the company. So in determining what the interests of the company are, should we be looking solely at the interests of the shareholders, which is the case under the existing common law, or should other stakeholders be other stakeholder interests be taken into account? This issue remains critical because although the existence of powers of control of shareholders over the board is important in giving effect to the shareholder primacy model of company law, the nature of the fiduciary duties of directors still provides the framework for permissible action by directors. In the UK, in the end, the pluralist or the pure stakeholder approach was rejected, and what was enacted was what's referred to as the enlightened shareholder value approach under Section 172 of the UK Companies Act. And under that section, directors are expressly required to have regard to stakeholder interests, but the ultimate duty is still to promote the interests of the company for the benefit of the shareholders as a whole. So the idea there is that to the extent that acting in the interests of the other stakeholders can maximise profits for shareholders, then that is the extent to which directors would need to take into account interests of other stakeholders. So this issue was also looked at in Hong Kong in the company law reforms just over a decade ago before the enactment of the current Companies Ordinance in 2012. The Hong Kong debate never really went as far as considering whether a pluralist or a pure stakeholder approach should be adopted, but there was consideration of whether to adopt the UK's enlightened shareholder value approach. And in the end, the Hong Kong government did not enact a similar provision to the UK Section 172 in the Hong Kong's Companies Ordinance. The reason was that the government considered that it was unnecessary because under the common law, although the fiduciary duty of directors is to act in the interests of the company, which means the interests of the shareholders as a whole, but nonetheless, the common law fiduciary duty is still permissive in allowing the directors to take into account the interests of employees or other stakeholders, with the proviso that doing so is ultimately in the interests of the shareholders as a whole. So this position under the common law, which remains the case in Hong Kong, explains the possibility of corporations in jurisdictions such as Hong Kong adopting corporate social responsibility or ESG. In Hong Kong, for listed companies, the stock exchange, under the listing rules of the stock exchange, there are requirements for listed companies to have ESG policies and to make disclosures about their policies and what they have been doing on the ESG front in an annual ESG report. So for Hong Kong companies then, it is lawful for directors to take into account stakeholder interests because of the permissive aspect of directors' duties. But while large corporations often emphasise their ESG credentials, the company law framework being based on shareholder primacy, ultimately does require directors to promote the financial interests of the shareholders. So with the law still embedded within the notion of shareholder primacy, there are clear limits on the ability of directors to act in the interests of other stakeholders, as seen from Professor Hutchinson's presentation. Thank you.